second that we have is DocTutorials, Edutech Private Limited versus Telegram and others. Again, a Delhi High Court case decided in January 2022. So in this, the plaintiff, which is DocTutorials, it's a medical entrance coaching platform. They provide online content in form of videos, test series, and a lot of other material to prepare the children and coach them for the upcoming medical entrance examinations. So here what has happened is two unknown entities have hacked into their system, and their material and the notes and the videos for coaching were given out on different platforms, including Telegram. In this case, the question that was, the issue that was in contention was that whether plaintiffs is entitled to injunctions, grant of damages, and protection of copyright over the content. Now, since this falls in the domain of educational material, so there was a question of copyrightability that came up, and also because the parties who had allegedly infringed were unknown, they could not, there was a question to be decided as to how to ascertain liability in certain situation. First of all, it was held that there was copyright over the content, because even though it's coaching material, educational material, it is done for a standpoint of a profit. It is a business that runs on, and there's a lot of effort that goes into making those materials, videos, and test series to be relevant. And the other platform, Telegram and Mega, the platforms in question, they do have a responsibility as to the kind of content that is being circulated over there. Now, since Telegram's sharing model is as such, as long as you do not exceed a certain limit of GB of storage in your sharing platform, there is no subscription per se. So they do not have any personally identifiable data that they collect, except for email ID, which is, or a phone number, which is required for you to sign up to Telegram, or for IP addresses in certain cases. So it's very difficult to identify who is the person, who is the user, and exactly pinpoint his location or his personally identifiable information. So in a situation like that, it was held by the Delhi High Court that from future point onwards, when a notice is provided or notice is served to Telegram or other such intermediaries, it is their responsibility to take down the content of infringement immediately upon notice without any delay. There did not be a formal judicial mechanism for that to be overcome before the material could be taken down. And the second thing is, for unknown sites or IP addresses or URLs, which cannot be properly identified or blocked by intermediaries, in that scenario, Department of Telecommunications has to be alerted, and the department has to take down such infringing URLs within 48 hours. So this is very significant in establishing owners of intermediaries in cases of unidentified infringers of copyright.